everyone for joining this session on digital asset IP rights, sponsored by Sheppard Mullin. The topic of our panel today is covering your digital assets, intellectual property rights and gaming, protecting your brand in games. I'm here today with Jim Gatto, Hank Leung, Owais, who will be speaking on the topic. So just as a background, when it comes to digital assets and gaming, obviously IP is a top of mind issue. And with the breakthroughs in gaming, there's a more diverse ecosystem than before. It is one thing to create an iconic IP that resonates with the audience. It is quite a separate and equally important conversation about protecting it and capitalizing that value, as well as the derivative opportunity. So let me just kick off by introducing our honorable panelists. So first of all, we have Jim Gatto, who is the blockchain and digital currency team leader of Sheppard Mullin. Next, we have Hank Leung, who's partner of Bird & Bird. And last but not least, we have Dr. Owais, head of legal and IP of Quick Trust. So please, can we have James give a quick self-intro, followed by Hank and Dr. Owais.
Sure. Thanks, Esme. Welcome, everybody. My name is Jim Gatto. I'm a partner at Sheppard Mullin. We're happy to sponsor this event. Should be a great conference. My background, basically, I've been doing game work since the 2000s and have worked with companies as they kind of went from selling packaged software into the digital economy with virtual currency and virtual goods. Got very fascinated by the business model and legal issues and continued to do work with game companies ever since. Got involved with blockchain around 2012. One of my clients became general counsel of the Bitcoin Foundation, got me kind of dragged into that, and I've been doing work in the blockchain space ever since. Been doing NFT work for quite a while now, but it certainly has kind of really accelerated in the last 6 months with kind of the boom and what's going on. And we help companies with everything from protecting IP, doing IP licenses, doing a lot of the other kind of technology agreements around that, as well as the regulatory issues around securities tax and money laundering and various other issues.
All right, so next we have Hank. Hank, please introduce yourself.
Hello, everybody. Like many of the attendees and speakers at Game On, I'm a very avid gamer. I've been playing video games since the days of the original gray box Nintendo and the Japanese red and white Nintendo. And I've owned every version of the Nintendo since then and many other consoles. I currently spend most of my time playing PC games on my Alienware. I've been playing games such as Apex Legends, Teamfight Tactics, PUBG, Rocket League, and Overwatch. But the game that I'm most obsessed with is Valorant. So if there's any Valorant players in the audience, drop me an email to play the new episode. Besides gaming, I practice IP law. I'm a partner and co-head of the China IP group at Bird & Bird. We act for a number of top game publishers, esports leagues, and also esports teams. We've been doing lots of interesting work in this sector. So like Jim, we've been doing a lot of work from the whole spectrum, from protecting IP rights to enforcing IP rights, and helping them with license agreements, sponsorship agreements, and other technology agreements in the sector.
All right, so let's last but not least, let's go to Dr. Owais to introduce yourself, please.
Thanks, Esme. Thank you very much. This is Owais, and I am a legal advisor to Quick Trust, which is basically a blockchain-based startup working in the area of NFTs and trying to build a new solution towards NFTs and IP. I'm not as avid gamer as Hank here. I would rather say much of my focus on gaming comes from what I'm actually practicing, or let's say teaching, which is predominantly in the area of IP and at times competition law. And so this is pretty much, and I also advise startups, technological startups on IP and competition law strategy. So this is pretty much what I do.
Right, sure. Thanks very much, everybody. And very quickly about myself. So I'm Esme. I'm head of emerging technology research at China Tonghai Securities. So for most of my career, I spent in sell-side equity research and global investment banks. And I've also spent some time in corporate VC and also looking after the startup ecosystem. So in terms of my favorite games, so I used to game Age of Empires and Civilization. These are my two favorite games. And the similarity with most of the panelists here is that I also was an educator in law. So that sets a great background as to all of our intros. So gentlemen, let's just jump right into the topic. So in terms of the first part of our conversation today, so I'm going to ask some questions to draw some of the high-level themes and also trends that we're seeing in this space. Okay, so let's have the first question fielded to Jim. So Jim, as the blockchain and digital currency lead of a top-tier law firm, you've had a lot of experience dealing with clients in this field. So for my first question, how has IP ownership in gaming been traditionally protected? And given the massive change that we're seeing in terms of digital transformation, what would be these implications on ownership of IP rights of games?
Sure, great question. So, as far as traditional IP protection for games, really all the forms of IP can be available. If you have functionality or kind of processes, you can protect it with patents. Certainly, there's a lot of visual aspects of games which can be protected by copyright, trade dress, and other forms of non-patent IP. Trademarks, of course, for brands are very important. And I'd say those are among the most important. Then you have trade secret, a lot of data and other stuff that really is not commercial, kind of publicly available. You can protect that as well. So that's kind of very high level, kind of the historic. And really, all of those forms of IP are applicable to NFTs. We're seeing companies patent kind of interesting technologies around creation, delivery, and interactions with NFT, kind of on the functional side. And same with the kind of design and look of the digital asset that's associated with NFT. Of course, all those traditional forms of IP are available to protect those as well.
Right, sure. And Hank, would you have anything to add to that?
Yeah, so I think what's interesting is that traditional IP protection of games is that it's all within a closed ecosystem. So you have the game developers, and they would own all the patents, the software, and within the game they would own all the digital assets within the games. And then you see the commercialization of the digital assets is really generally by way of a license, right? So if they create a skin to sell within a game, then they can sell as many skins as they want. They just create one copy of it, and then everybody can own the same skin. But I think the unique attribute of NFTs is that it's non-fungible, right? So I think the digital assets that's being created within the games will be unique. And then so if I own a digital asset within the game that's an NFT, then you cannot own it, right? So there's the rarity aspects of it. So I think that's what really probably the biggest change in having NFTs in the way that they're commercialized within games.
Mm-hmm. Yep, that's interesting insight. And I have a follow-up question for you, Hank. So given that you are a go-to source of legal advice for IP protection and enforcement for some of your major clients, which include top media and sports firms. So I would like to ask you, if we were to look across the spectrum to different forms of IP protection, say copyright, trademark, and now there's NFTs. So how would you advise your clients as to the different advantages and disadvantages in terms of affording protection to the creator and other stakeholders?
Right. So I think we need to clarify that NFT itself is not really a type of IP protection per se.
Mm-hmm.
I mean, the law hasn't really changed to what is an IP, right? So it's still the copyright and trademark, and those are still very important, right? Like copyright in the software and the artwork, and trademark for the brands. And I think those will continue to be very, very important for game developers to protect and register where it can be registered. So NFTs, I think it's just, I think you have to view it as an asset, right? An asset which represents certain other, usually in relation to games would be digital artwork or digital assets. And I think, the game developers or publishers, they're not going to, I think they would develop NFTs in a way for commercialization. So they want to sell the NFTs. But also, I think the interesting thing about the NFTs is that you would want to make it a more open ecosystem where you're involving other creators that's creating digital assets that's being sold or transferred in the form of NFTs.
Can I add something to Esme? I think that's
Yeah.
a great answer by Hank. I think one thing I think it's helpful for people to kind of understand, because NFTs, you don't really see the token, right? So it's kind of sometimes hard for people to kind of get their head wrapped around it. But as Hank alluded to, the token really is just a representation of ownership that gets recorded on the blockchain. And what it represents is some asset. It could be physical or digital. In this context, it's typically digital. And so when you look at from an IP protection, the token is ownership, but the digital asset is like any other digital asset. But, we advise clients to look at all forms of IP protection and develop a comprehensive IP strategy around the digital assets. As we talked about earlier, patents, copyrights, trademarks, trade secrets, design protection, etc. Usually the NFT the token itself, because it's recorded on a blockchain, doesn't really have a IP associated with it, but there are some exceptions. There are some companies that have created a brand for their tokens. So like Top Shot, Dapper has Top Shot moments, right? And so there can be some brand around a series of NFTs, even though each one is unique. But that's the way they brand the NFT. So we kind of try to break it down between the token and the asset that's represented, and develop a comprehensive IP strategy around each of those components, and looking at the different forms of IP.
Mm-hmm. Right, that's very interesting insights. And next, then moving on to Dr. Shay. So you have had very globalized experience. So you were part of WIPO, and then you're also, being an advisor for head of legal for Quick Trust, which is a startup in digital IP. So given your extensive world-class legal experience, both in academia and also a practitioner in IP law, I want to ask a question as to what is the value for creators or owners to digitalize their IPs?
Yeah, thank you, Esme. I'll just go back for a quick point, and Hank and Jim have pretty much covered all the points. The only thing that I'm going to highlight is the fact that when you talk about IP and when you talk about NFTs, we're essentially talking about intangibles, and that's why we are talking about these two at the same time. When primarily in the digital world and in the non-digital world, we have seen that IP law has played its role. But increasingly in the last 10, 15 years, we have realized that the IP law that have been created were not created for a digital world or with the digital world in mind. What was created was essentially for an industrial economy, and then gradually, because changing laws is not that easy, so we still are using the same IP laws, tweaking them again and again and again and again, and making them relevant for the digital environment that also includes gaming as well. But as we go forward, we realize that a lot of the areas are still very difficult to be covered through law, and that's where blockchain or NFTs come in, because it's much easier for somebody to validly or somebody valid to create a digital representation of ownership of something that may exist in the digital world or in the non-digital world. Like focusing on gaming basically has and predominantly has been in the digital world, as Hank also mentioned in his introduction. So for gaming, NFTs come very naturally. That's the pro for NFTs. but the con there is, and then I'm coming down to the second question that you just asked, the kind of value that can be had by digitalizing your IPs, is that IP in the digital world has not been new. Those who were there in the late 90s remember very well that there were two main treaties from the World Intellectual Property Organization, and they collectively are called WIPO Internet Treaty. The word digital has actually become so common right now, but back then people were actually talking about internet. The internet at that time was pretty much new, and that was the new thing to talk about. And gradually we see that within those treaties and the implementation of those treaties, especially when it comes to Europe and the US, we were primarily, I'm making it very brief, primarily focusing on IP protection, how the rights that have been granted through the statutory laws of copyrights, of patents, of trademarks, have to be implemented in the internet age, in the digital world. So that was the start of, let's say, the discussion about in the digital world, the IP intersection, and then fast forward, as Jim also said, early second, early to 2010s, and then now late 2010s or early 2020 when we were talking about NFTs. So NFTs now have given the creators an opportunity to actually represent their own ownership beyond simple discussion of enforcement of IP rights on the in the digital environment, but now through the NFTs, at least at least from an argument perspective, NFTs will enable, or they do enable, creators to represent their work in a digital environment through a certification, which which is based on IP laws, but is still beyond or let's say step forward in terms of digitalizing the rights. So from that perspective, NFTs are kind of a jump from industrial era like IP laws being used in the digital environment to a pure tool to digitize intangible assets in the digital world. That's the kind of value they create for creators.
Mm-hmm. Dr. Shea, so you've mentioned some very interesting points, and I'd like to stay with you for the next question. But at the same time, I hope would Jim and Hank be able to think about, what other things you'd like to add in terms of the value for creators and owners to digitalize their IPs. And Dr. J, in the meantime, I'd like to look into the quick trust and also the opportunity that lies ahead. So can you give us a background about quick trust? So what pain points is it trying to address, and how is it solving some of the major problems that we're seeing in the digital IP and gaming space? And following this, I'd like to ask you further about what milestones are you looking to hit in the future, say 2 to 3 years?
So when it comes to IP, we have to realize that in terms of intangible assets, and my panelists also will agree, a lot of assets that are of a lot of use for creators may not be protected by IP. For example, small data. A lot of in many cases, if we are granted right, let's say, of a trademark or a patent or a trademark, uh, an unregistered trademark, for example, is not the same as a granted trademark because the burden of proof shifts and all those kind of things. But they are still important and it's still useful for creators and for creators especially. Think of characters in games. Think of different volumes in if you would like to have them protected, different jurisdictions will have different provisions or laws regarding those. What Quick Trust is trying to do is actually to create a um, creation of digital assets through its platform, where we are focusing primarily on content that is possibly copyright protected, plus that content which is of enormous value to creators, but creators would have difficult time in registering that as a traditional IP, say trademark or copyrights, or even in terms of patents. So what Quick Trust provides is a platform that where you can actually, as Jim also mentioned, create a digital ownership of your asset that may or may not be in the digital world. But with Quick Trust adds a twist to it, and that twist is that Quick Trust adds or creates a link between the underlying asset, the NFT, as well as the identity of the owner. So what we are trying to do is to enable anyone to make provenance really mean more than simply provenance. So you can actually not only identify the asset, but also identify to the specific person with the identity who is holding it. So that's the disruption, if you may, that Quick Trust would like to bring to this area.
Right, sure. I think that's a solution that's very much needed. So, Jim and Hank, I'd like to see if you have anything to add in terms of value addition in terms of digitalizing IPs for creators, because I know that's a very big topic. So we benefit from your multi-dimensional view.
Sure. So I think a couple of things. One is just to pick up on the last thing that Dr. Owais said. When you link ownership, right, and the identity of ownership of IP through an NFT, one of the most powerful things that I think that NFTs enable with the assistance of smart contracts is for IP creators not only to sell their IP and get paid, but to keep getting paid. Right. Mm-hmm. So with digital art and various other assets that are represented by NFTs, and this even applies to tickets and various other things, you can structure them so that you get paid on the initial sale, but through a smart contract, a percentage of any resale can also go back to the creator. So we see many artists, for example, who sell their works for practically nothing. Then they get really famous and those works sell for millions of dollars and they get none of the upside. Right? That NFTs change this. This is a fundamental value proposition that is different than what's out there in the world right now. As a corollary to that, and this goes a little beyond NFTs per se, but the whole idea of kind of the ability to track IP through a blockchain and use smart contracts to automate payments is going to be revolutionary beyond what I just mentioned. You think about the music industry, which is so fragmented. You can have multiple copyright owners in one song. There's so much money paid to people to just track who's entitled to royalties and how much they're entitled to, right? So if you create it's going to take a while to get a blockchain solution for that because there's so many different players and it's a very fragmented market. But it's a great problem for blockchain to solve, because once you start putting songs out there where the ownership is identified and the stakeholders are identified and the royalty payments are identified, you can have smart contracts automate those payments and the reporting, and you're going to cut out layers of people. Sorry to all you out there who do music licensing and collect royalties, but it becomes unnecessary. So I think that, from a really big picture perspective, I think those are two of the, fundamental value shifts that we're going to see over time with NFTs and blockchain.
Yeah, and that's a really good point, Jim. And I think relating to just creators, so that, as you mentioned, the smart contracts allow creators to be paid. And if you apply that to games, so imagine that somebody's creating a map for a game or a mini game within a game. They can get paid through other players playing those games. So if you create, say, for Mario Brothers, if you create a new map for Mario Brothers, as long as people are playing that game, you can get paid if you're the creator of it. So that creates a lot of different possibilities for creators to commercialize their work.
Right, sure. So we've already talked a lot about the upside in terms of NFT and also digital IP protection. So I would like to discuss about the downside and also the deficits that will need to be addressed, given that, everything is moving along at light speed. So we need to make sure that we're able to protect ourselves. So this question goes to Jim. Um, you have already recapped how the gaming NFT space has evolved in the recent years, but I want to ask what kind of deficits are you seeing and how have you been advising clients as to how they could protect their interests and also preempt potential lawsuits?
Sure. Well, there's a lot there, but so and it, for different players in the ecosystem, the answer is different. But if we look at traditional game companies, I think what's interesting is a lot of the big game companies really haven't jumped into the NFT space yet. And you talk about downside right now, and I think Hank mentioned this earlier, when game companies, they manage their own economy, and it's a closed loop economy. They can create more of a good if they want to. They track the ownership. For the most part, it's not legal for players to sell their in-game items on secondary marketplaces, although we know that happens. And so the game companies have control over everything for the most part. With NFTs, it completely changes it, right? So players now can take items, bring them outside the game, and sell them, and that's part of the model, right? It's not illegal to do that. And so I think from the standpoint of game developers, this is a very different paradigm, and they need to figure out how do they take advantage of that without the downsides that necessarily come along with it. One of the downsides I will tell you from a legal perspective that is an issue that needs to be addressed, and we work with clients on this all the time, is right now a lot of the traditional games, we'll call them, a lot of the money they're making, whether it's through loot boxes or other forms of in-game sales, a lot of it is chance-based, right? And so if you have a chance-based model, there's been a lot of gambling lawsuits against game companies, right? And in most cases, the people bringing the lawsuits have lost. But gambling, just at a high level, if people pay money for a chance to win something of value, that can be gambling, right? There's some exceptions, but at a high level. So what game companies have traditionally relied on is the fact that the in-game items really don't have value because they can only be used in game for entertainment purposes. And there's a number of cases in the US that have found in favor of game companies. If you use chance-based mechanics with NFTs where people can sell them for value outside the game, right? That's one big area where the way in which game assets are sold needs to change in many respects, because if you have chance-based acquisition of valuable items, you might run afoul of gambling laws. So that's kind of one big issue, not an IP issue per se, but that's an issue for game companies that they need to deal with.
Yeah, if I can jump in. So,
Sure.
and besides, I mean, you made a very good point on gambling and loot boxes. But I think another area of concern for a regulator is from a securities law perspective, because as we mentioned, NFT is really a token that represents certain ownership of certain assets, and really, in principle, that's not really any different from financial securities. And I think once the NFTs are being exchanged or being offered to the public, the securities regulators become quite concerned that this is just another type of financial securities, and then they'll want to regulate it. So that's something to keep an eye out for.
Yeah, and security and the challenge with for game companies, for example, the securities law is very widely around the world right now, and there's not a lot of harmony. And the U.S. SEC has taken action against a number of companies, more so on the ICO side. I agree with you, Hank, that securities laws it's an issue we talk to every client about to make sure what they're doing is not a security. I think one of the things with NFTs that makes it a little bit easier is that, at least in the U.S., is that generally what one element of the test for whether something is security that the SEC applies is whether there's some common interest in some asset, and if it's bought for for profit purposes. The SEC has issued guidance, though, and in many cases, because NFTs are unique, you often can avoid the common interest test. Now, not always, right? So people right now, for example, are fractionalizing NFTs, right? So you could take a very high value asset and create a number of NFTs that represent a portion of the ownership. Then there's a common interest, and fractionalized ownership definitely can raise issues with respect to securities. That needs to be evaluated, very carefully. But the other thing that's interesting is that, when you look at it, Hank is right. A digital artwork is an asset, right? And so it can be a security depending on how it's structured. Based on the guidance the SEC has given in the US, though, is that if something appreciates in value, not because of the effort of others, but because of market demand, then that element of the test is likely to show it's not a security. And so the typical situation where a crypto asset is a security is, you go out and you raise money, you sell, you do an ICO like people did, in 1819 and, for a while there. And that's how they funded the development of a platform. And in that scenario, those were likely securities in most cases because people were investing money in these tokens with the expectation they were going to make money based on the effort of others. And that effort of others was assuming the platform developer built the platform the tokens are going to be used on. If that platform came to be, then everyone made money. And that's kind of falls into the classic definition of securities under US law. But when you already have an existing platform and you're selling NFTs on it, each NFT is unique. If it goes up in value because, like CryptoPunks, right, because there's just greater demand for individual works, that typically is not a security. So again, the laws vary by country, but in the US, many of the NFTs that we've seen probably are not securities, assuming you avoid fractionalization, assuming you avoid selling them before the platform is built, and some of the other scenarios that we've seen.
Right.
If I quickly jump in
go
on
ahead,
this,
please.
I do agree with both Jim and Hank. My take is a little different in the sense that obviously the law is in flux right now, and primarily we start from the term tokens, and then we kind of make that connection with securities law. But if you look at it from a different perspective, we're talking about nothing new, which was not happening before the NFT or the blockchain it was not popular. So digital assets were being created in the digital environment, and they were being protected as an asset through the IP laws. So one way of actually pushing this would be to actually make an argument, at least, if not insist, that a fungible token is for a reason non-fungible and is different from a fungible token, which may be considered, or where all these arguments may exist with regard to them being securities or not securities. So with an NFT, we may actually also look at it from a perspective of what the IP law primarily was protecting in the digital world, and how does NFT does the same thing, or does it also introduce something different than what was IP law simply was doing by creating a statutory right and a presumption of ownership in the digital asset itself.
Yeah, I agree with that. I mean, the NFTs represent ownership of something, and as Dr. Owais says, you have to look at what the something is. And if it's just a digital asset, right, just like people have sold digital assets forever, if it's just represents a one-off of a digital asset that you can currently use, you're probably not going to have an issue under U.S. law, at least, and probably many other jurisdictions.
Right, you've raised some very interesting points, and that flows to the next part of the conversation. So it's about the current status of law. So across the spectrum of blockchain, so there's a DeFi, which is almost completely unregulated, and on the other hand, so there's STOs in which regulation is following closely behind, and we actually have a very effective fabric in terms of regulation covering that. So I'd like to cover NFTs. So do you think it's a fair comment to say that law is looking in the rear view mirror in terms of the IP and gaming space? And to what extent do you think the law in relation to NFT and digital assets is going to evolve? Jim, can you please take that?
Sure. So, with very few exceptions, and again, this is in the U.S. and other jurisdictions, the answer may be a little different. There really are no laws on NFTs right now, right? So, the SEC, the gambling laws, money laundering, IP, all of the traditional laws apply. All right, there haven't been new laws created for the most part. So the challenge is identifying how those laws apply. And so the major US agencies that are charged with regulating different aspects of this, the SEC and FinCEN and others, have issued guidance on how they interpret the applicability of existing law to NFTs and other crypto assets. Their guidance is not law, right? And there are some lawsuits right now challenging their guidance in different scenarios. So I think one thing from a US perspective that we'll see is that as there's challenges to agency guidance that may change the application of existing law to it, there are some proposed laws in Congress that would address certain aspects of different types of crypto assets, but none of them have been passed at a federal level. There's some states like Wyoming that have tried to create a very crypto-friendly environment, and they've created some very specific laws that really only apply in Wyoming. So I think the big picture is there's no new law. We're trying to fit, and I think Dr. Owais said this earlier, right? We're trying to take existing laws that were developed a long time ago, and were designed for industrial, IP, and we're trying to fit digital assets into them. And then, that happened in the the late 90s and 2000s as we move, into the internet age. And now we're even more challenged trying to take these into the NFT realm because there's other issues that arise. And so, to your question, are we looking in the rearview mirror? 100%. The law always lags technology. That's just a fact. And I think that it's inevitable that we'll see new law either through court decisions that interpret agency guidance or through Congress actually passing new laws or tweaking some existing laws. We saw that with, going back to the internet. One of the, I think one of the most fundamental early laws that was passed with respect to IP and the internet was the Digital Millennium Copyright Act. So typically, if you post something online, if you're a site and you're hosting, if a user uploaded content and you made that content copies available for people to see, technically that's an infringement because you're making a copy of a copyright protected item. And so early on, the DMCA provided a way to shield online service providers from liability for copyright infringement under at least certain circumstances. But we haven't really seen any analogous laws at least from an IP perspective in the NFT space.
Right, sure. And next, I would like to hear from Hank about the Asia perspective, because after all, so Tencent and Alibaba and some of the tech giants are doing a lot in the NFT space. And afterwards, so we're going to summarize with the pros or wisdom that each of you will share. But Hank, over to you in terms of the Asia perspective.
Right. So maybe just my own suspicions on the regulation of NFTs in China. So China, you can probably make some projections just based on the features of NFTs. So NFT, not too different than say like Bitcoins. China really doesn't like anything that would affect its control on your currency and financial controls. So once your NFTs economies popularized, and then you see added values to NFTs, I think you're gonna see probably a regulation on NFTs in gaming in China. That's just my speculation. In terms of the outlook for China, it's a very interesting market. There's 600 million gamers in China, the biggest gaming market, and with the demographic of mostly millennials, there's a huge potential for growth. And the Chinese government has been generally quite supportive, of the gaming industry and esports. There's lots of domestic incentives and support for the gaming companies. They've even made esports an official sport since 2003. So the government, in some ways, is quite supportive. But then, on the other hand, it's also can be quite heavy-handed in regulating the gaming industry. So, and a few days ago, Chinese government issued a policy banning gaming companies from providing online gaming services for people under 18, except for 8 to 9 o'clock in the evenings on Friday, Saturday, and Sunday. So this is limiting gaming to three hours a week. So I'm sure kids these days spend way more than 3 hours in a typical week playing games, and that kind of sudden government policy directives creates a lot of risks for companies operating in China. We also see similar types of issues in the whole game license approval process in China, where there's a lot of uncertainty in the whole licensing process. But I think even with all the regulatory risks in China, the Chinese gaming market is just still too big for any gaming company to ignore. So I think we'll continue to see a lot of growth in the market despite the regulatory risks. And then I think the other region of interest would be Southeast Asia, Philippines, Indonesia, Thailand. That's going to be with the demographics and the access to mobile phones and internet. That's going to be the huge growth area for a lot of gaming companies, especially in the esports.
Right, sure. So we're all, time flies when we're all enjoying ourselves, and I definitely am, and I can speak so on behalf of everyone. So it's time to wrap up, and before we close, so I'd like to spare 30 seconds for everybody to please share your insights or pearls or wisdom with the audience and something for them to take away with. So we'll start with Dr. Shay and move on to Jim, and we'll close with Hank. Dr. Shay, over to you, please.
Oh, I am only going to say that gamers are in for making a lot of money when we're going to have a lot of NFTs, and Trust will be the place to go to create the NFTs. Thanks.
I would just add that while we've covered a lot of interesting legal topics here, this is just scratching the surface. I think it's really critical for anyone jumping into the NFT space to get solid legal counsel at the very early stages to understand the legal issues with your business model.
For me, I would just say that you never know what's going to come around the corner. NFTs has been around for a while, and it hasn't really exploded until probably last year. And then, just keep an eye out for new technologies that's going to game change the gaming industry.
That's a great pun. So with this, we'd like to bring this panel to a close. And once again, on behalf of the sponsors and also the organizers, we'd like to thank all panelists for tackling this very meaty issue. And thank you, audience, for your time today. Have a great day.
Thanks, everybody.
Thank you.
Hi, everyone. This is Charlie Hu, the managing partner of Lucid Blue Ventures, the head of China for Polygon. Polygon has been actively growing in the Web3 gaming and the metaverse field in the last couple of months, and we have tremendous support and adoption in the ecosystem right now. And we try to bring the bridge between the Web2 gaming world and into the Web3. And very looking forward to the summit and hopefully to share some insights and meet new friends in the summit. Thank you very much.